Zebulon Zeb Chandler is a GLA member attorney and an Atlanta, Georgia entertainment attorney at Chandler & Chandler Law Group, focused on music, film, and technology law. Mr. Chandler studied at Atlanta's John Marshall Law School, where he earned his JD, and at University of Georgia, where he studied business and earned a BA in Management Information Systems. Zeb writes blogs and legal guides, which are shared on his law firm website at chandlerandchandlerlaw.com. In his free time, he enjoys sports, foreign languages, reading, and music. Tonight, we will be live tweeting the event, and the handle is at GLA_arts, hashtag GLA seminar. And thank you, Zeb, for coming to speak with us tonight.
Thanks everyone for coming out tonight, first off. It's only a little pressure when I've learned there's 80% attorneys in the room or professionals in their trade. And so just to get started, to give you all a brief background, I graduated with this guy right here, Mr. Shannon Slayton, 3 years ago, passed the bar 2 years ago, and have been in practice ever since with my father, who's also here, Walker Chandler. So I've got him looking over my shoulder. He's going to pipe up if anything I say is really off base. But I basically wanted to keep it short, not bore y'all, and so I have a 3-part presentation. The first part is a PowerPoint that I put together that just talks about identifying the basic structure of a contract, the components of it. Then the second part that I wanted to get into more than just the nuts and bolts is strategies for negotiation. How do you balance a deal that's really weighted towards one party or the other? And so the second part is not really a slideshow, and the third part is questions and answers. If there's any particular things we want to talk about, we can talk about, in a blend of the second and third part, we can talk about a lot of the real common contracts that people face these days. But basically, and again, I don't want to sit here and read slides or tell you all too much. So if you think about what a contract is, in the very beginning, let me back it up right there. See, it's a little slow. You want it to be an organized agreement. The basics of a contract is it's a promise exchanged between two parties where there's consideration involved, and it's usually fees going to one group in exchange for services on the other hand, or some other transaction. So you have these basic, the whole contract runs from your beginning to the middle of the purpose, to the middle parts, which might be the terms, to the end. And so if we think about identifying the parties as our first part before we get to anywhere else, this is all the first block. Because a contract, I could sit here and have example contracts and blocks and bodies of text and all, but if you're a visual learner, these are just some of the key components that you're going to want in that first paragraph. You want the title to say performer agreement. You want it to say songwriter agreement. You want to identify what you're about to talk about. Then in that first paragraph, you want to identify the parties, also identify any aliases, where they live, and how you're going to title them in that contract. And then most likely, but not always, you'll include the project itself. And so the project would also have an example here in the project. And so I was thinking of putting in blocks of text, but you'll see some examples as we go through the slides of those elements in play. But almost all of these elements are just a very important first part in your introduction. So there's a few different ways you can set up that introduction. This might be the beginning of a talent agreement, right? So you have your title at the top. Then you have the parties. And so a singer-songwriter, AKA an alias, who resides at, then you give their address in case there's multiple artists under that name. And then herein, for the rest of the contract, that person is going to just be called the artist. So this is an important part of identifying the parties. And then down here you see they enter into this talent agreement for the purpose of producing and distributing an album entitled Project. And so then you don't have to put the name of the album, you don't have to put the name of the artist, the long name of the company, in any future reference to any of those key things. So that's one example of how you might put that intro together. Another is this. Somebody might have it be like a generic form that you agree and you negotiate, but they still want it super clearly defined who the parties are. Because if you have a party ambiguously characterized, or maybe you wrote down one of their name, but it's not their correct and full legal name, and then they say, oh, I was doing a deal with them and I didn't know who it was, and you just don't want the trouble of them having a foothold and being misidentified, either side. So that's a very important part of the introduction. But like I said, I could go on and on about each little part, let me go the other way, of a contract, but we'll just kind of run through them all, and we'll just talk about the components. This is the beginning, then you have the purpose, and then you have the terms, then you have a signing part. So we're just going to run through all that just to get an idea of some nuts and bolts, and then we can talk more about these different contracts in play. Okay, so the purpose of the agreement, this comes right after the introduction. The purpose is to do what? It's to produce a TV show, to produce an album, to lease artwork to a performance theater, if you're a muralist or something like that. So there's all types of different purposes, but this is key language that falls in almost all contracts. There's other ways of saying it, and there are modern contracts that don't use these two words, but this is an easy way to demonstrate purpose, and you use them in all caps. So I'll show you an example piece of text, but right after your intro, you need to have this before you start listing terms. This is what engages the two parties into all the terms together. It's a call to action, it's your verbiage, there's a lot of ways to look at it. So here's an example of it. Whereas party A and B wish to write and record songs, and whereas they wish to make their mutual efforts clear, therefore, and then usually they use this. This is kind of legal language. In consideration of the mutual promises, valuable consideration. You keep seeing the word consideration because this is the part of this contract. That's part of the function of this section. So this is really there are contracts out there. You can get them off the web. You don't have to have a lawyer draft you a contract if you're an artist or whatever. But this is one of those sections where properly wording is key, and it's not normal wording. It's not artist company language. It's legal language. So this is one of the few sections where kind of going the tried and true route is a little safer, a little better. And also, we all have enough attorneys in the room, attorney friends, to get that language clear before you go any further. But usually when you're reviewing a contract that someone has submitted to you, that kind of language is going to be already sufficiently worded. So now if we jump into the terms, I always like to numerically categorize the terms. Occasionally a contract will have an alphabetical list, but these are basically separated elements of what each party promises one another. It can often be real simple. Here's my artwork. Here's the money you're going to pay me for it. Here's the performance I'm going to do on this day for 4 hours, and here's the money you're going to pay me for it. But when it's a collaborative effort, when it's people filming something, taping something, in a studio together, performing at the same time in a function with like visual performance or something else, there might be a lot of other conditions, and that's where we get into all the terms and their setup. So the next slides, so we say all the terms add up to your contract, but let's take a step back. So these slides, they didn't show up that great, but you see the word term in blue. All of the ones coming up, the next little set of 10 or 12 slides, I'm going to go through pretty quick, but they're just terms you may or may not find in a contract. So we also, I looked at the title of this talk, and it said to identify clauses that you might see as well. So think of terms as essentially one clause laid out, but this is all everything's variable. So some terms can be very long, some terms can have subpoints to them, and things like that. But essentially, they're separate, clearly defined parts of the deal. And if we jump right in, the definition of the project is a key term. So you might find a paragraph that says the project will consist of electronically created masters of XYZ quality burned onto XYZ medium, a DVD, a CD, a physical body. A lot of times you're going to see that. So these are the kind of things if we jump ahead to negotiation, you're not going to worry about negotiating this kind of a term. This is one that you just recognize, you identify, and say, oh, that's what that term's about. Now, this is a little tricky because we talk about terms, T-E-R-M-S, then this is the term of the contract, or the length. So, I'll come back to this later when we talk about negotiation, but term of a deal can be the most important aspect in the whole deal. Because when you're binding yourself to someone else in a collaborative effort, the duration of time that you lock in to working with them is so critical. You might be an artist and you might say, okay, we're going to do a record demo, and you have 6 months to shop it to a major label. But at that time, then I get the control of the demo. Or at that time, if I get signed to a record label, you only get a real small percentage because you helped me make the demo, but you didn't effectively shop it. I went out and got a deal without your help. So those terms and how they wind down, we'll talk a little bit more about that later, but it's so important. And and it's not so simple because, like we said, there could be subcomponents, cycles, extensions, elevations, triggers. We'll go to some of what those mean, and ways that they can extend the term, give one party the option to create a longer deal, etc., etc. Scope of activities. How far does each party have to go to do the project? How many hours? You might like we said, a demo, you might develop it internally, and then one party's in charge of setting up business outside, external development. Fees. So this is obvious term in the contract. It's a huge one. The compensation, how it's paid, money up front, money upon the completion of the project, how it's accounted for. Those are. This is another subset of how the profits are divided. So you might have fees might relate, if I back up one, to your upfront fees for a concert. Oh, an artist gets $5,000 guaranteed. And then the profit sharing might be essentially the first level of bonuses. Okay, assuming that we have 1,000 people attend the concert and pay full price for the ticket, then there'll be this much extra. How much does the promoter get? In that example of an artist doing a concert, you might have promoter, club owner, artist, or something like that. So now we get into ownership rights. Who owns? A lot of this is kind of basics. I don't want to spend too long on each one. And if there's anyone that you have a question about, just make a mental note and we can kind of come back to it. Ownership rights. Who's going to get to keep them? Usually the company paying will get to keep the product that they develop. But in music, it's more often shared, and then certain rights are shared certain ways. They have mechanical and synchronization rights. Worldwide rights might be different from domestic rights, or you might get more money or less money on certain groups. Licenses and other rights might be reserved by one group. So creative control. Sometimes an artist who is in a position of power or has a big fan base or has a backing and a long catalog, they might want to retain creative direction and have particular veto rights that can give them some say-so over any final approvals of what gets to market, whether it's a TV show, whether it's an album or whatnot. Production and delivery schedule, I didn't even need to put any notes in because you all get the idea that just says we're going to do it over this period of time, we're going to deliver it to these other parties. So, cycle options. This is a part of extending a term. This is a really key part to television deals. The cycle options. So no one, quote, gets rich their first year of reality TV is a big set, motto in the industry. But what happens is if they place someone on television and they turn you into a, quote, star, then they're going to want to have the right to continue riding your, stardust as you're on TV and become a popular person. So they try to create, it's just like a record label deal. They create a series of initial seasons of your show that they've had you contracted for, and then if they so choose, they can add additional seasons, and those are called cycle options. Same concept goes for record label deals with people doing albums or singles. You can have them based on seasons, episodes, albums, singles, but basically a cycle option says once the company decides to do X, they pay you maybe a cycle pickup bonus, and then you are now obligated to perform for another 8 songs for the next album, another 12 episodes for the next season, or so on. So those oftentimes too, just to get back to, and we'll talk about bonuses, you can have the money escalate as the cycles escalate. So if people want to continue, your artist or your client makes more money as the deal gets longer. This again goes back to ownership, audit rights. I don't want to spend too much time talking about it, but audit rights include your ability to go check the books and what gets discounted from any royalty or upfront money deductions. You don't want to enter into a deal where the company can write off everything and then essentially have a very successful project get watered down by all the marketing money that's spent on other projects that aren't your own. So that's an important aspect. This breach, cure, arbitration, notice, these are all other terms. And if you guys want, I'll make these slides available to you over email. We can always exchange information at the end. These would all be separate, but it's often what you see some boilerplate, but it's important because what does constitute a breach? How does one person cut the other person out of the contract for bad behavior? If someone fails to pay or fails to perform, cure is what opportunity do they have to fix that problem before the contract is void and breached. So cure might be something, we didn't pay you your last bonus of $5,000 for the new season. Well, we might reserve the right to have 90 days to cure the problem. Or we can, if we pay half that sum within 90 days, then we can continue the contract, and so on and so forth. And arbitration, and then notice is the example of, in a lot of contracts, when and where and how you notify the other party if you have a question, a complaint, a request for them to cure, etc., etc. So definitions, important part of a contract, might come on in. In contracts, we use our own specific definition of words that has to do with things like industry standard, that have to do with our own particular specifications for that project, for someone's actions that we expect or anticipate. So there's plenty of ways to reference it, plenty of ways to define them, but a good way to always do it is go look at other industry standards and try to have a definition that conforms with an industry standard, and then if you need any specific detail beyond that, then add to it versus trying to rewrite the book on the definition of some component to a contract. Exclusivity. Again, all the terms that we have in blue are not going to be in every contract. Everyone's different. Some contracts might only require 2 or 3 of these things. It might require fees and a term. It might require a lend out and a bonus, and that's it. Exclusivity would come into play when you have an artist who is doing a particular project with a particular group and who normally might work with a lot of other people, but you want them to work with you exclusively. And so, because it's a big deal, the right of first refusal, perhaps you have a star, or let's not say a star, a regional celebrity in Atlanta goes sign a deal for a television development deal. They most likely are going to be restricted in the other TV-related things they can do while they're engaged in that contract. And so maybe another small TV network here in Atlanta says, oh, we know you're doing this show with so-and-so. Can we just come have you as a guest host on CNN? Well, then that network that you did the first deal with, the development deal, has the right of first refusal. They get to say, no, you can't, or yes, you can, go on CNN and just be a guest. So those are the examples of how an artist will be limited in a contract. And so you might think about those as, those are the alternative streams of income and other things like that. And oftentimes the contract will go into high detail. I don't know why I put a pineapple there, but I just added one to keep it interesting. And this is indemnification, because it's a boring part of a contract. Indemnification, I wrote it up there better than I can say it. All these things, just because we sat down and decided to do some work together, doesn't mean you can go sue me if you get hurt or something happens to you during the course of it. Or, we're going to go do a reality TV show in the Amazon together. You can't sue me for loss of income because you left your other job to come film this show. So this is just one of these lawsuit protection sections that goes in a contract. It's important to look at and identify. Nothing is irrelevant, or nothing in a contract should be just completely glazed over when you're reading it. But this is one of those standard type things where you just want something that's not way too broad, and you want it to generally limit the scope of other people's ability to sue you for things that are outside the contract. Okay, bonuses. So in a lot of entertainment deals, a bonus structure is more important than the fees. The rights to a percentage of the royalties, the rights to any additional monies earned on a project. If the label all of a sudden is a small label and they have success with a single and they elevate it into a larger label, does that artist get a piece of that bonus? If any new money is made off the project, if it's used in a commercial, does the artist get some of that? Because if you don't protect these things, then you'll see things blow up and become big successes, and those people who are on the camera or who are on the microphone aren't getting a big piece of the pie. So if you think about all your entertainment projects, 90% are going to fizzle out and not be a hit. And then there's 10% that'll get on some radio station or some airplay or some DJ's playlist, and there's a very few percent that make it into the national and global market. So if there aren't these kind of things tied in from the beginning, you can really get cut out of all the large money later on in the process after everything gets going. So these are all kind of important parts. We can talk about them more when we get into the negotiation, but we'll just stick to components. Confidentiality. This project's a secret, so let's keep it a secret. And this is just a little non-disclosure agreement within the agreement, usually. Don't forget, signature block at the very bottom. And this is just you want it a little more detailed than this, but this is after all the terms. So we're done talking about terms. We've talked about the intro. We've talked about the purpose language. We've talked about terms. Now this is just the last part. And so this is where you sign. You might have, just like in the intro, you might have another line that says dated, or you might have company. You might write out the other person's, have another by, write out their name in text underneath where they're signing. You might have one that says print and then sign. And so just a little hint while we're talking about that, or not a hint, but just something that I've learned from other people in the past, as the larger and more complex the contract is, the more thoroughly you should have someone sign it. You might even want to put little dashes in the bottom of the corner of it, pages, where they have to initial it on each page, because a 20-page contract with just one line on the bottom last page is not as convincing as a contract that has a dash out by a lot of key terms with the artist or the participant or the company's signing authority out on that mark. So I think I pretty much got through everything in my PowerPoint right there, which is all of the the basic terms in the beginning, so I won't skip back forward or backwards through it too much. What I wanted to get into is and again, this is like, we're not trying to go sit here for 1 hour and drone on and on. I wanted to get some feedback from you guys about what types of contracts have you seen recently? Have you felt like there is room to negotiate, or any questions? Because I'll just go ahead and kind of get into questions, because I don't want to talk about just music contracts or just reality TV contracts or visual art contracts. I get a feel for what y'all are looking at, and then maybe we can talk about where we go back through those terms to look for negotiation work. So any volunteers on contract types?
I've got a question.
Yes.
It's sort of more of a strategy thing, so hopefully
go
it won't
ahead.
go into the
Yeah, go
negotiation piece too big. But if you're presented with a contract and you can tell that it wasn't written by someone who really understood all the legal parts to it, is it better to try to work with them to edit that contract or to present a new one?
That's a really good question, and that comes a lot of times. You really, like you said, when you do it, you base it on the expertise or the professionalism of the parties. And if we digress a little bit, one thing that's important to realize is, since somebody gets a lawyer in a deal, so many entertainment deals are not represented on both sides. It's two people just collaborating on something. And so then all of a sudden it looks promising or something. So one of them goes and gets a lawyer. The other one is going to tighten up, thinking that, oh, they got a lawyer. There's this lawyers steal rights and money from people on paper and make it legally enforceable. So if one party gets a lawyer, it's very important for that person to help dispel the myth of evil lawyers and say, what we're trying to do is make a clear agreement between the parties. What we're trying to do is just lay it out there so we can examine it better. So in that situation, if it was done in a polite, nice manner, in an understanding way, and let's make a more clear understanding versus I reject what you're presenting and here's something better. I think a countering with your own contract might be better. But again, I always tell people, even if they have a poorly written contract, or use their own language in your counter. Don't try to change everything, and work with what you have. Any other types?
I'd like to just put in only a couple of minutes. First is, Zeb's real good about talking win-win. And that's, any contract is win-win, because once they've been signed, that's when they're enemies. Before that time, they're just negotiating. So it's win-win. A contract is a great opportunity to play what if. And a lot of these amateur contracts don't have enough what if. What if the guy dies? What if such and such happens? It's all about fighting ambiguities, isn't it? And you want to fight all that right up front. One of the ways I like to fight an ambiguity in a contract is set out an example. You know, if they say we're going to divide profits 50-50, well, what are profits? Gross profits, net profits? How do you define gross and net? And how do you keep one side from cheating? Because if it gets to be $100 million gross profits, it'd be ridiculous for the artist to get $20. At the end of the day, I thought Zeb's discussion of duration of a contract was very important, because that whole thing about, hey, well, I own you forever. You signed this contract back when you were 18 years old, and it was ambiguous, and by implication, you belong to me now. There's also one little point I'll try to.
One thing is, I was going to say, that's important to realize when you see, that's the thing. One of the things that happens is lawyers get to start playing what if. They get to start trying to be so clear that they write a 20-page contract. And the real trick is in negotiation, if they present you a 2-page deal, you maybe rewrite it, but it's still a 2-page deal. It's still 3 pages. It's simple. It has only a few things added that you want to clarify. You're not trying to change the whole language and the whole tenor of the deal, because one of the things that if we get back into that unrepresented negotiation, people sometimes say, oh, I got this young artist, talk to me about a 360 deal, talk to me about this. And I say, well, first off, there are scrupulous people and unscrupulous people. And for someone to work in a collaboration in a positive way, then you have to have a balanced deal. You can't have one side owning the other side and getting the vast benefit of the economic interest. And so sometimes people are like, oh, I want to sign this person for X number of albums or X number of deals. And I say, well, I can help you review it and write something, but I'm never going to go to the bargaining table and present someone a too lopsided exploitational deal, because that's what gets argued in court anyway at the end of the day. You want a balanced deal so that people can't all of a sudden start suing each other over things, and can't all of a sudden say, I was a minor and you had all the bargaining power. Even if the bargaining power is one person is writing the check for the studio time and brought the songs to the table and is going to present the album to major labels, and the other person's just a singer and that's all they have is a voice. Even in that situation, it's in this person's best interest to protect that artist to some degree, because it's going to be important later if that project progresses. Because if you do, quote, wrap them up completely, you do take all of the future possible bonus money, excess profits, then that person is going to sue you to get out of the contract in 2 years once they become a star, and you're going to spend forever fighting them when you could be working together with them because you gave them a piece in the beginning. So it's important about that exchange of the pieces. So I wrote him out little negotiation notes to look over the whole deal first, pick what's most important to you and to the other party. So you're going to create two lists: the things that you need in the contract or what you're getting, and the things that they need, and the most important things, and think, if I need to add something to my side, what can I add to theirs? Or what numbers and things can we adjust? And so numbers are always easier to adjust than verbal language. So always look to those. Duration, money, bonuses, those are going to be your best opportunities to squeeze more balance in for your client, whether you're representing the company, the producers, or the artists, the talent. Length of time, duration again comes back in. So term is huge, because if a deal, for example, is a small deal, it's, I want to do a few songs with you, and when we do a song together, here's how we split it. That's great, and it doesn't bother the artist at all if it's only 1 year, if it's only 10 songs. But if they have to sign a deal that says we have to continue proceeding for 2 or 3 albums before I start making more money, then you're going to have a problem. So that's why an artist would want to squeeze the term. Hey, if anything, let me make it shorter. If anything, let me have a little bit more money or adjust these parts. So I have beware of over-lawyering or people tightening up when, quote, other people say they get their lawyers involved. It's so important to dispel the, I don't know if it's misinformation or not, that lawyers are out there to swindle someone out of their rights, swindle someone out of their money on paper. So you have to have a lawyer you can trust, that your opposing party can trust and have some respect for, because when you come in with a greedy mentality to the bargaining table, it just doesn't work in entertainment, because entertainment is so much more about collaboration. It's not like a shipping contract or a raw materials contract. It's much more about both parties being properly incentivized, so that because it's so much involving creativity, and to get creativity going properly, you have to have everybody in, everybody succeeding and sharing the economic benefit. So I wrote down some basic types of contracts, and then I might just hint on or mention a few of the points that might be more focused on in the negotiation for each one. Artist-producer agreement. That is a very big, wide open subject. Artist-producer can be a graphic artist. It can be a music artist. It can be an actor. Producer can mean essentially a music producer, can mean a TV show producer, can mean a promoter, it can mean a million different things. So that is this, it's like I've been wanting to write a blog all about this. What is the perfect artist-producer deal? And there is no one perfect deal. Each one is going to be different. But that one is one that has a lot of fluid moving components that can be negotiated, because usually when you're entering a deal like that, suppose it's a TV producer and 5 girls who live in a house on a mountain or something. That producer is not some Hollywood exec working for Warner Brothers. They're essentially on the same level as the artists. So they're making an agreement, and maybe one of the artists, actors in this situation, maybe it was their idea for the show. So they're trying to contain and keep some of the ownership of that creative rights. So like we said, the term about ownership and copyright might be more divided between the parties in that kind of an agreement. So that you can see how if we listed 15 terms there when we were going through them, the 5 or 10 of them might be negotiable. Compensation, timeline, the upfront fees, the profit sharing, bonus structure if the album got selected or if the show got picked up. Then if we get into the more heavier contracts, I just wrote label deal, 360 deal. That can also be a television deal as well, where someone is getting signed to a major company, and that major company wants to make them a star, but also control some degree of the income that they can make in any format. So if someone's a music artist, they sign a music contract, but the fact that the part that makes it 360 says, if you as a music artist go get a shoe endorsement, we get 15%. If you as a music artist go do a commercial or a live show or anything else, we don't just produce your albums and make money with you on iTunes. We make money with you whenever you make money. And so that's the idea behind a 360 deal. So it can occur, and usually when it's in television, it's called a talent agreement. But that 360 deal, might be a recording agreement with a label, but usually it involves one party being more high-level, national, international label, production company, network, media producer, and the other person being, they might be an artist of some high stature, they might be an unknown, but because they're in those different positions, that deal is going to be more comprehensive, and it's going to be harder to pull out the pieces that are negotiable. So again, you have to look for bonuses, you have to look for numbers, those kind of things. If we talk about singer-songwriter deals, that's one. I'm just going to mention a few, and then if you guys have any questions about negotiation stuff, you can just ask me, because I'm going to just wrap it up and then open it up for any questions. But singer-songwriter agreements, shopping agreements, that's kind of like a confidentiality agreement. Lease out license agreements, a lot of people do that for visual art. Talent agreements, TV development, artist services, performance agreements. All of those different ones, you're going to see a lot of the terms we talked about. They're going to be, some aspect of them are almost all going to be negotiable, even a 360 deal. You can at least negotiate better money, hopefully. But then, before I go to questions, the one thing I think that's important to realize, when can one negotiate? Do they have to just take the deal that they're offered? There's so many aspects to making yourself more viable, profitable, intriguing to the other party. But one of the key things is for an artist to have their own independent fans and following and followers online and everything, because if you already have that, you can be sufficient doing small little things yourself and stay afloat. If you don't have any of that, you just have some hot song or something, then with no fans behind you, you're totally relying upon the label or the television program or whatever to add the fans as well as the content and everything else together. So you really have to give up a lot more. Whereas if you kind of grow your own movement and then you start negotiating, they're going to want to bring those fans into all of their other programming, all their other artists. So that just gives you more room at the leverage negotiating table. But any questions? Because I don't even know how long we've gone. I might have ran through it all, but I know we have a lot of attorneys and law students in the room. What kind of stuff have you guys been thinking about before you came in here that you might wanted to discuss or learn before you got here that I might not have mentioned?
My name is Jaron Clark. I'm from Louisiana, and I guess it's a triage of the agreement between a non-singer, non-producer, lyricist, all the writers of lyrics, between that person, the lawyer, and a music publishing company, or what contracts are involved in that kind of deal.
A lot of times when a person writes songs, I tell them to go do their copyrights themselves, because then they can start building a record. It's like an artist recording in a studio. The more music, the more songs you have under your belt. So that copyright side is a start for the lyric writer.
Right.
But then when you get into the contracts between them and lawyers and them and music publishers, it depends on. So let's take, for example, a songwriter writes 10 songs, and then an artist finds one and becomes interested in doing it. Then maybe that artist's label company are going to come present the songwriter a contract, and at that time, you might, because they selected your song, they came to you. It might be their contract. They might have a form, but you have negotiating power because it's your song. I think an important aspect of that to get paid, maybe not the contract control part, is doing copyrights and just getting registered with ASCAP or BMI or CSAC, because it's like a union. They're going to give you more opportunity to go collect money. But as far as a deal with a publisher, I think that would probably be on an independent record label deal. It might be 1 or 2 pages, and it might be regarding that one particular song. But it would be nice and simple, especially if you have the copyright already done and the artist already wants the song. But I really only think there's probably only one contract necessary in that situation between the music label and the songwriter. But I might be wrong. And the deal with the lawyer is you probably, there's so many different ways, you can figure out fees and your agreement with your lawyer, but that's just yet another contract.
Right.
Whether it's how they're representing you, if they're moving, if they can act like a manager to some degree and try to help shop your music to people. But there's also a fine line between lawyer and manager, and we can talk about that in a little bit if y'all want. But lawyers can't go do shopping of certain types of things in certain markets, because in states like Florida and California, there's agency law, and then you have to work through an agent and whatnot. But we can talk more about it. But any other questions or contract types or clauses? I know I'm putting y'all all on the spot, but I feel like I've just been mowing through slides. So, any of these slides y'all want, I'll make them available to you. Also, one of the things about Georgia Lawyers for the Arts that I like, and a lot of times when an artist is looking for a lawyer, looking for some legal advice, they say, oh, the lawyer says it's X amount of dollars up front. And then we'll print you off a nice, quick, easy contract. A good way for people to work with lawyers and get the same results with not as much of a legal tie-up is there's plenty of existing templates online. Take them, disassemble them, use notes like these to put them back together, and then go say, can you review this for me? Can you look over this? Because that's another thing when we were just talking about with Julie. She was saying you respond with edits to their contract, or you respond with a new contract. And I think, generally speaking, if you're representing the artist, it's almost always a good idea to respond with their contract, just because they're in this financing position. So it's that's just one of the basics, but it's all about the bargaining power. It's all about how much your client is bringing to the table and how much the person buying it or hiring them needs that work. Because certain types of art, certain types of things is you can't go find a replacement on the street. Other types of programming you can go do an overcasting and find someone else to do that role, a survivor or something like that. So, any other questions? Comments? Feedback for me? Well,
This was great. Thank you so much. Y'all.
appreciate y'all.
And I will say, and I don't mean to camera. That's why we're here, is to help y'all. If you do have a contract, we can get an attorney to review it if you qualify for our for preventive services. If you need a contract drafted, we can have one of these attorneys do it. Also, I just want to say thank you so much, y'all. It doesn't seem like a lot to create a PowerPoint presentation. I know it, but it takes a lot of time, and so it's I really want to say thank you to Zeb, because this was fantastic, and I know that it's not an insignificant amount of work.
No problem. And I don't even know how long we went as far as the total allotted time, but the what I was mentioning about GLA is also as good as that they have a vast archive of good contracts. There's so many deals on a small level can be done in 2 or 3 pages. You don't have to pay an attorney to go do that. They don't need to make a new one. There was a person referred to me through GLA that was a young artist, and so their manager wrote me a long email. Oh, this is all the stuff we're worried about, and I thought to myself, oh, all they need is this contract, and then if they want to add 1 or 2 things, then add it. And so when they finally looked at this one that I sent them from online, they were like, oh wow, that does cover it, and I could use this every time. And so a lot of times you mentally have this idea that there's 10 issues, but there's actually a contract already written somewhere that's been used by plenty of successful people that have 9 of those 10 issues covered. And so I like to go look for Tyler Perry contracts, stuff like that. I'm like, what did he do? And he just made it real simple. Or some other, Steven Spielberg's original deals with George Lucas. Those kind of people, these contracts that never went to court and yet produced millions and $10 million and $100 million ventures. Some of those are only 4 pages long.
I got a question about that.
Go ahead.
So where do you find the good contracts versus the bad contracts, and how do you determine that they are good ones?
That's a impossible to answer question, but I like it. It's you have to just do a lot of searches. I have subscriptions to some kind of white paper databases. One big one that I use is Scribd, SCRIBD. Those are $5, $10 a month sometimes, but you can kind of search more high-value documents, LexisNexis and Westlaw, and the normal legal search ones will offer you enough court cases that refer to contracts where you can go look at it that way. But and then certain websites like I want to say there's ones for, suppose you're a startup and you're going to take in financing and issue stock, or someone's going to become a member of your LLC or something. There's plenty of websites that just have like 5 or 10 good contracts in there on that site, and that people refer to that site as a good site to go to for those kind of things. But again, what's good and what's bad, you really have to take them apart, digest them, and then think about, not the contract, think about your own deal. What's the handshake that you're trying to consummate? And you can always kind of edit and fix other deals to make it work for yours. But I would say there's probably 10 or 20 main basic simple contracts that people don't need an attorney for. Art lease out, a song license, a beat license from a person who does an instrumental and they want to work with a singer or somebody who writes a song, the lyricist's a basic contribution, songwriter's contract with a record label. You as the songwriter list, and then it would have a series of blank lines. This song, this song, this song, and this song. You grant the rights to the record label for 10 years or whatever for X number of dollars. And that's it, because those songs are all in the, referred to in the copyrights. But, so those are some of the basic deals that make up a large amount of the contracts in the market. Then the big ones are rare, and when you do come to them, an attorney, having one is useful. And I think that one of the big things, if I just spend one last second on negotiation is so much better done face-to-face than over email. When you have a person dealing with a record label, or you have a TV person in a network or something like that, the attorney or the agent, whoever's doing the representing, there's so much value in them flying to go see the other attorney face-to-face. Or just like when the musician was auditioning to get the record deal themselves, the record execs wanted to see the person's face. They wanted to see how they were conversationally. And so when you have a representative, an attorney, negotiating a deal for you, it's almost like insist if you can, to say, hey, how much is it going to cost me for you to go do this negotiation face to face? And especially if the two parties are in the same city, there is no reason for someone to be emailing copies back and forth when they can sit down and talk about it, because that also builds that friendship. You want the company's lawyers to be cool with your lawyers, and not either party to be like, I hope he doesn't bring the lawyer. Don't tell me he's talking to the lawyer. You want them to be cool with everybody, and that just makes the negotiation process more flexible and more viable to balance a deal. But so now, I guess I am finished with my ramblings on and on. But thank you all for coming so much and supporting GLA. And I have my cards up here if anybody wants an email of these slides or anything like that, or want to ask any other questions, do any other discussion, not in a seated standing format.
Great, thank you.